Hello everyone and welcome to another edition of our video newsletter. In this video I want to talk to you about the idea of filing a Marchman Act while somebody is being held in a facility under the Baker Act. So we get a lot of calls from people who have been Baker Acted, and now a family member wants to use the Marchman Act, which is Florida's involuntary commitment statute for substance use and co-occurring mental illness, to put the person into treatment. And as a general rule, I will tell them that it can't be done. And here's why. So the Baker Act, which is Chapter 394, the Marchman Act, which is Chapter 397, is an emergency stabilization statute. And if your loved one has been Baker Acted, it basically means the state has stepped in and taken control of their life. Now, initially, that's only supposed to be up to 72 hours, but it can be extended. The facility can go to court, file a petition for involuntary placement, and in theory, that individual, your loved one, could be held for up to 6 months. So right now, the state has complete control of the situation. If you go get a Marchman Act court order, that order is a treatment-specific statute, meaning your loved one has been ordered into treatment. It doesn't tell the Baker Act facility that they should release the person. It doesn't tell them anything about what to do with the person. So in theory, your loved one's being held at a Baker Act facility. You go get a court order that says to your loved one who's now being held and says, you will go to treatment. The problem is they can't go anywhere until the facility decides to release them or a judge orders them to be released. So as a general rule, if your loved one has been Baker Acted and you want to get your loved one into treatment, there's sort of only two ways that happens. One is the state agrees to allow them to be transferred sort of on a bed-to-bed transfer. But the problem with that is that once they're transferred, they're no longer under a court order. They're no longer in the control of the state, and they are then free to sort of leave and do what they want. If you want to get your loved one into treatment and keep them there while they have been Baker Acted, the best way to do that is a guardianship. So the guardianship allows a family member or somebody that's designated by the family to step back into the state's shoes and take control of the situation. Because right now the state has control and you as the family member have none. Zero. So the guardianship would allow you potentially to step back into the state's shoes, take control of situations, and make decisions for your loved one once again, one of which would include sending them to treatment. Now, the favorite two words we learned in law school is "it depends." And I say that because there are exceptions to this rule. So are there times when I will file a Marchman Act when someone's been Baker Acted? Yes, but only if I know or I'm reasonably certain that the Baker Act facility is going to respect and recognize the Marchman Act court order. They're not going to abuse the Baker Act statute and look to keep the person. If I know they're going to stabilize them and then they're looking to release them and they're willing to sort of comply with the Marchman Act order and agree to release them to the facility that we've designated and which a judge has ordered in the treatment or assessment order, then yeah, I can file a Marchman Act while there's a Baker Act case pending. But as a general rule, the answer to the question of, can I use Marchman when there's a Baker Act is no. With that said, thanks once again for tuning in. Stay safe and be well.